Okay, good afternoon. Because of the time constraint, we have to make sure that we have do this on time. Make sure that we finish it as. Good afternoon. My name is Natapon Rathi. I'm the head of experimentation. It's quite a fancy name from UNDP Accelerator Lab, which is lab working on innovation and development. It is my greatest honor to serve as the moderator for the session. With the COVID-19 pandemic, we have seen courts move fast into digital world. They're now holding online hearings and using digital more than ever. Things like artificial intelligence and online platform are reshaping how courts work worldwide. But here, the thing is, judges and people in this realm shouldn't be just the users of these technology tools. They have a deep understanding of the rights and issues that come to court. And they understand the need to look closely at new technology to ensure people's rights are upheld. But often, we know all the time that when new text projects are rolled out in the courts, people planning them don't involve users like judges, like stakeholders enough. So this can lead to big problems like denying people their rights, putting vulnerable groups at more risk, and even risking people's privacy. So it is crucial that judges and stakeholders here play a big role when a new technology is brought into the courts. In this session 3, we will deep dive into how technology affects the quality of justice and people's access to it in ASEAN. You will see examples, discuss the hurdles, and think about the ways that we can use technology to make justice more open and efficient for everyone. Today, we are honored to have representatives from ASEAN countries to share their challenges, success stories, insight, and future perspective on the role of technology in justice. Please allow me to introduce you, our panelists today, starting with Judge Graipon Aranyarat from Court of Justice of Thailand. The second one, Judge E. Lee, Constitutional Court, Republic of China, Taiwan. And we have Ingrid Rosalind Gore, Senior Advisor for Justice Institutions, Government of Injustice or GoJust, the Philippines. And Ken Hui Tan, Chief Transformation and Innovation Officer from Supreme Court of Singapore. Each panelist, we have 12 minutes. Make sure that you make it on time and to share the experience and applying technology in the justice system. If we have enough time, we should have the Q&A session. So firstly, I would like to ask Judge Graipon to share the story from Thailand to the audience. The floor is yours.
Thank you so much. And let me have a clicker. Let me share my slide, please. All right, let me test. Can I go back to the, okay, that's the first slide. Okay, thank you so much, everyone. Thank you for having me today. But first of all, I just want to give you a little bit about my background so that you get a sense and understand the context of the work that I involved with. Right now, I'm not conducting the judicial hearing because I'm now working at the Office of the Judiciary, responsible for a lot of administrative stuff for the Court of Justice. And a part of my job is I'm a part of the team that trying to make sure that the implementation of technology is aligned with the provision of the law and trying to make sure that the technological implementation of the Thai court is proceeding smoothly and seamlessly. So it's going to be a very useful and a great opportunity for me to share this stage with all of you. And my focus today is going to be the impact of the technology on access to justice. And I'm not focusing on the technical issue because I'm not the expert about the technology. All right. For the first issue that I would like to share, next slide, please. Okay. The first two I just want to share is the challenge on access to justice. For now, I think Thailand is facing with at least two issues relating to the access to justice. And the first issue is that I think right now, a lot of Thai people is still living in the poor condition, and Thailand is still facing a lot of problem regarding the inequality in terms of social inequality and financial inequality, something like that. So a lot of people in Thailand, then when they got some kind of problem and they want to go to the court, a lot of them just simply give up because they didn't have enough money. They could not afford the legal representation. They could not hire a lawyer, right? And sometimes they just simply give up. So that's going to be the first challenge that the judges and the policymakers, they have to think of the way to implement technology to empower these people, to empower them to protect their right without the need to go to consult the legal professional or something like that. I think that's the first challenge. And the second challenge that I think we have to address here is that during the past 5 years, the Thai Court of Justice, we have been trying to implement a lot of technologies, but a lot of the court online service, we are lacking the idea of inclusivity, which means that at the beginning of our project, I think we didn't think of the something we call the universal design and the inclusive design of our initiative. And that makes a lot of people, some group of people could not equally benefit from our tech initiative. I would like to give you an example. We have the e-filing system that we've been using for almost 5 years or 6 years, but the e-filing system, it can help people. People can submit their legal documents, legal motion, or legal complaints to the court electronically without the need to physically appear at the court. But I just realized, I just learned from the project that the Court of Justice just did at the beginning of this year, that there are still a lot of people that could not use the e-filing system. And some example is that the lawyers who partially lost his vision, and some lawyers that they are colorblind people. They said that the e-filing system did not have the accessibility tools. They could not navigate through the interface of the e-filing system. They could not adjust the size of the font. They could not adjust the color or even the sharpness of the e-filing interface. So make it difficult for them to use it. They have to ask for other people to help them to use the e-filing system. So I think these stories make us realize that another challenge that we have to overcome is that we have to build the inclusive design platform that allow people, every group of people, to utilize from it. That's the challenge. Actually, we have a lot more challenge, but because of the time limit, I think this is the most important issue that I would like to mention here. So go to the next slide, please. No, previous one. Okay. The second issue that could not just ask me to share is the success story of the Court of Justice of Thailand. But I'm not sure whether this could be considered as success or not, but I'm going to tell you. 2 years ago, the Court of Justice of Thailand, we established the special division for the online transaction dispute in the civil court. And this special division is working as a special tribunals or special courts dealing with the online transaction dispute. And for example, when people they got scammed online, or they didn't receive the products or the services that they ordered online, they can file the complaint to this special division. And we're trying to build a platform, electronic platform, to use specifically used with this special division. And we combine a lot of practical tools, for example, the e-filing system, the electronic case management system, and the web conferencing platform. We combine it and develop a platform that user-friendly for even a average people can use it. So they can self-litigate without going to consult the legal professional or something like that. But if you think about the old days before we established this special division, people who got scammed online or they want to stand for their right, they have to go to the court and they have to fill in the court form, which pretty, pretty technical. There are a lot of legal jargon and require a legal background to fill in the court form, right? So people, they have no choice, right? You have to go to ask the legal representation and pay for the lawyer fees. But with this platform and with this special division, they can do it by themselves because we built the platform on the idea that even an average people must do it by themselves, can do it by themselves from the beginning to the end. It's very easy to navigate. And I think right now it's pretty successful because we are witnessing and we are experiencing an increasing number of the victims who chose to use this platform to file their complaint. And I saw in a lot of court users, they review the court process in this special division. They review it on TikTok, they say that it's pretty easy to use something like that. So I think they are pretty successful and people just, I think they're satisfied with our special division. And so I think this success story that I just want to share. All right, turn to the next, previous one, please. Okay, how can technology could help? I think if you think of technology, I think technology is like a magic that can do anything. But in terms of judicial proceeding, I think technology could help at least 3 aspects. The first thing is that you can use technology to empower people, like the knowledge empowerment. This aspect is simple and very straightforward. You can just, the court can publish the information and the guidance on a preparation to attend the court or something like that on the court website. And you can even develop the court chatbot or something like that so that the chatbot can answer some basic question or the repetitive question that people normally ask when they have to attend to the court. Yeah, that's the first aspect. But the second aspect that technology could help is that it helps people to access to the court from anywhere in the country. They don't have to come to the court physically or, it saves a lot of money for them. This is pretty obvious because during the COVID-19, I think a lot of jurisdictions around the world, they use the web conferencing platform to enable people to access to the court from anywhere. And last but not least, I think technology could simplify the court process. Like I mentioned earlier, in the special division of the civil court, we are trying to use technology, build the platform that very easy to use for people, and there is no need of the legal knowledge to fill in the court form and to navigate through the court process. These are the benefits that technology could help. Next slide, please. All right, but technology also comes with the risks and challenge. And the first aspect that I would like to share is that the situation we call the digital gap. Because when we imagining the electronic court service, we probably think of the system where every stakeholders, they're involved in the digital ecosystem. But the reality is that there are still a lot of people in Thailand that could not even afford the technological devices. And some of them they are not comfortable with using technology. But if we rush them to use the technology, to involve in the electronic ecosystem, it turns out that it's going to restrict them from access to justice. I think we have to beware of of the result of the technological implementation. The second thing is that you have to think of the law. The implementation of technology should not violate the legal provision. It must comply with the requirement of the law. That's the second thing that is a challenge. And the last thing is that I call it myself the cold justice, the low touch justice, which means that when we're trying to implement a lot of technology, sometimes we are losing the human element, human interaction during the court hearing. You know, people come to the court. You can imagine if you are a victim to the case and you want to seek for justice, you bring your case to the court. When you come to the court, all you see is the computer screen. What do you feel? That's what I call the cold justice or low touch justice. It would be like sometimes the traditional model when people come to the court and they meet the judge like face to face, they can communication directly to the opposing party. Sometimes they can settle the case without going to the court, to the trial, because you know with human interaction, human element, you can show your empathy. You can, you can face to face, having the face to face conversation. It can resolve the problem sometimes. So this is the challenge that we have to overcome. And if I were, I think I'm running out of time. If I were to give you a lesson learned, I would say technology is not the one-size-fits-all solution. We cannot just simply apply technologies and let it work. It doesn't work. You know, the real challenge is that we have to build the responsible digital court where you can leverage the technologies, and at the same time you provide the equitable justice, access to justice for all. So if I were to give you other countries and some of us some recommendations, I would say that if I want to implement the technology, I would emphasize on these three things. The first thing is that I will always prioritize the inclusive design in my tech solution. So that is to make sure that every stakeholders, every group of people would benefit from my new tech solution equally. Everyone can use it. And the second thing is that trying to simplify every step of your new solution, which means that you have to make it easy for an ordinary people, for the average people to use it without the need to consult the legal professional. That means it's easier for them to access to justice. And the last thing, always put the human touch or human element in your digital framework to avoid the cold justice or low touch justice. Because as I mentioned earlier, the human interaction probably helps solving the problem. So not only just building a high-tech court, but also a high human touch court. That's a very important recommendation that I would share. And that's my take.
Thank you very much, Judge Gaipon. It is very excited to hear that you mentioned a lot about human, about a lot about touch. Actually, at first, I'm wondering if you put typo. I thought it's low tech, but you mentioned low touch. Yes, so it's very important because device itself it's not alive. So it's just a device, but we human who made it we have to find a way to make it alive, using it as a tool that we can get in touch with people. And what Judge Gaipon recommend, another important aspect is that there is no one size fit all. So we have to make sure that the tools, the technology can respond the needs of the people. Let me pass the mic to the second panelist today, Judge Yi, to share the experience from Taiwan on the justice technology. Please, the floor is yours.
Thank you much. Thank you very much, moderator. And thank you. I want to first thank the organizer for having me here, and I'm very excited to share some Taiwan perspectives. My name is Yi. I work in the Constitutional Court of Taiwan. And firstly, I would like to introduce my function. So I am not leading a technology team in the Taiwan judiciary. I work in the building that you see in the cover of my slide. That is the Judicial Yuan, which is the centralized judicial administration institution in Taiwan. So part of my function is a member of the judicial administration, and another part of my function is to do research in the Constitutional Court. So today I will be speaking in the role both from a user in the Taiwan judiciary and from a member of the judicial administration. I would like to, before I delve into the court technologies, I would like to give you some backgrounds of how Taiwan began to digitalize the court activities or judicial or justice-related matters. So the background matters, I think. Another thing I would like to present to you is some of the recently adopted court technologies in Taiwan. And of course, some debates from the eye of the rule of law. So before actually talking about the specific court technologies in Taiwan, one thing that matters is why Taiwan opted for digitalizing some of the court activities. The reason there are two main forces driving the Taiwan judiciary going digitalized. One, in the beginning, the reason was from the people. So back in 2016, there was a National Affair Conference held due to another political reason, but there was a specific theme on judicial reform. During that conference, a people's consensus has been formed that the judiciary in Taiwan, the court activities in Taiwan must be digitalized to an extent. And the reason that the people arguing that the judiciary needs digitalization can be divided into two main aspects. One is they call for transparency of justice. And to be more precise, people are not entirely arguing that they don't know anything what's inside the judiciary is happening. Instead, they are arguing that people are arguing that the legal jargon you put in the judgments are too difficult to understand. And sometimes it is too difficult to comprehend what your professional lawyers or professional judges were thinking. So this is one aspect. And the other aspect, behind why people are calling for digitalization of court activities is that people are complaining that court procedures takes too long. So they call for more efficient court proceedings. So the people argue that maybe if we digitalize some of the court activities, then we can speed up the court proceedings. These are two main reasons behind the driving force called by people that we must adopt some court technologies. And okay, so to address this cause, some of the court technologies has been implemented, such as a sentencing system showing people how the sentencing decisions has been made. So there are the sentencing system published to everyone. Everyone can check the consistency of the sentencing decisions. And the responsive footnote addressing the complaint that the legal jargons are too difficult to understand. That is, if you move your mouse on the page that shows the judgment, it spontaneously shows what this jargon means. These are the gadgets responding to those call from people. And other thing is that we have the e-filing and e-delivery system from perhaps 15 years ago, and it's been still updated until now. And this can partially respond to the call from the people for a more efficient court proceedings. And the other force, let me move on to the other force that is from the judicial administration, because the judicial administration is clearly the institution that must address people's call. So the judicial yuan, that is the core, that is the institution I work for. They've been constantly reflecting how do we build a sustainable, pragmatic, also time-saving and integrated court system to address all these demands from the people. Why I say integrated? Because it is impossible to digitalize everything in one time. So you must integrate some of the digitalized part and the non-digitalized part and make it a full court document to make sure the cases go round. So what are the considerations of the courts, the judicial administration, is that we can use digitalization as the method to accelerate the court proceeding. But we are all lawyers, and some of our colleagues, we are all judges. We all know that the reason why court proceedings take so much time is very complex. And some of them to do with communicating face-to-face with the parties and trying to reach settlement in civil cases. And some of them are related to the cross-examination in criminal cases. And not every issue that takes time can be solved by digitalize everything. So the best we can do is, so the judicial yuan took a two-pronged strategy. So first, we do our best. We use digitalization as the strategy, as a tool to free up the most capacity in the judiciary. We free up the hands of judges and clerks, and we let them have more time to do other stuff. So, for example, we implemented voice input court minute, and we are also developing AI judgment drafting, which is very controversial. And these are the attempts that we try to save more time for judges and clerks so that they can spend more time on other cases to, in the whole, speed up the court proceedings in hope. And the other thing is to integrate the digitalized and undigitalized materials together. So we implemented online single sign-on e-case management system, which could be started with e-filing or without e-filing, just when a case comes to the court and the judge decides to digitalize everything. And okay, so for the interest of time, I will just focus on the last thing I mentioned, which is the e-case management. So this is apparently this is a system that transforming the court dossiers from paper copy to digitalized files, but it involves first one person, one party, or the court to initiate a digitalization. So I would just skip to what is happening now. In Taiwan, there is a stark difference in the use of digitalization of cases, there are almost 100% of usage in criminal cases using a digitalized form, but only less than 5% of civil cases using digitalized forms. And the reason, I think it is interesting, but it is relatable, because in the criminal cases, the person who initiates this is the prosecutor, which is part of the government. So if the government endorses digitalization, it will be much easier for everything go digitalized. And you don't need to worry too much about the defendant, because the defendants are well protected during the court procedures, and we don't set e-delivery as default if the defendant didn't agree. But in the civil cases, it is very different, because it requires someone to first initiate that. I want to use e-filing, and I want to receive the court documents. I want to inspect the court documents online with a single sign-on. And what if your counterparty, the defendant, does not agree? Then the court has to send a paper copy to the defendant, and then maybe get the evidence of delivery back and scan it back into a dossier, which is not entirely digitalized. So this is a prominent reason behind the stark difference between the civil cases and criminal cases. But there is a prominent beneficiary of digitalizing the court dossiers in even civil cases. That the beneficiary is the court. Because once, at any stage, if you digitalize all the court dossiers, what a court gains is that you don't need to spare so much room to store all the court dossiers for the closed cases. So we observed a phenomenon in Taiwan is that although during the proceeding of the civil cases, there are not so many cases being digitalized, but after the case is closed, almost 100% of the court dossier has been digitalized. So this is another thing that we observed. So let me wrap up all the benefits and the challenges. The benefits. So one thing I would like to mention is in the civil cases, the 2% of civil cases which went digitalized was mainly focused on the cases initiated by regular court goers, for example, banks and patent holders, enterprises. And of course, attorneys would love to use e-filing if they are accustomed to the digitalized environment. And for judges, it is not so prominent, but it may become beneficial to judges if the AI judgment drafting has become more prevalent in the future. And let us go back to the challenges. So the challenges of digitalizing the case files in Taiwan, as I mentioned, that in only about 2 to 5% of civil cases has been digitalized. So if you address that low usage as a challenge, it may be addressed as a challenge, but a challenge for whom? I would say it is a challenge for the policymaker who endorsed the digitalization. So it may be a challenge for the government, but it is per se a challenge for the core users. It's not necessarily. The challenges for the individuals, this is the thing that in Taiwan we concern the most, which is also the reason that the digitalization in Taiwan, we are not fond of the idea that going as a pioneer of digitalize everything, because we want the issue to be well debated in the civil society before we move forward. And there are some potential issues that if you digitalized everything, that means your court dossier, your court information will be more easy to subject to to be analyzed or synthesized. And there comes the follow issue will be the data protection issue of victims or vulnerable stakeholders. So let me wrap up. Apparently, I have used up my time. So the way forward is that the technology. I agree with everything that Judge Cry said. That technology improves court experience, and it may alleviate judges' workload, but only in the premises that access to justice for all is the limit, and the judicial independence is the limit. So when we are revisiting or we are assessing how successful we use court technologies, we need to always remember why we went digitalized. So this is some remarks and experience from Taiwan. Thank you very much.
Thank you very much, Judge Yi. Actually, I think the most important that we got from Judge Yi's session is the last sentence. When you get lost, when we get lost, ask ourselves first why we are here, why we go digitalize. And I think that could be from the two waves, right? The wave, the call from the people, and the call from the judicial administration. So when we go digitalized, we should make sure that we respond to these two waves from Taiwan. Thank you very much on this. And let me pass the floor to Ingrid. So it's heating up now, a more exciting issue, but we would like to hear the experience from the Philippines. That would be good.
Thank you so much, Nat. So before I start, let me introduce myself and my organization. I think I'm the only one here. It's not from the judiciary. I'm actually from a development agency implementing a justice sector support program in the Philippines. So we support the Supreme Court, the Department of Justice, and the Department of Interior and Local Government insofar as various justice sector projects are concerned. And my particular role is in implementing a lot of projects relating to automation. So before I go into discussion of technology, oops, sorry.
Technology.
Yeah, I'm pointing at the wrong thing. Okay, so, oh, wait. There. What's going on?
Come, I can. It might not be turned on. No, it is.
No, it is.
You want me to?
There. Okay. So before I go, I jump into technology, I want to discuss some of the access to justice concerns and issues in the Philippines, and the context of how this operates. So some fast facts: the Philippines is an archipelago, as Justice Singh mentioned. We have over 7,000 islands, thereby making geographical access a real problem in terms of access to courts. We have a huge population, diversity in language. Our courts have a huge caseload, but the more important issue is that the distribution is actually uneven, where we have, I think, around 300 to 400 courts that are overloaded, having maybe anywhere between 800 to 8,000 cases for any single court. And whenever we have overloaded courts, we also have jails that are congested in those areas. And this is why I think that improving efficiency and effectiveness of the courts is an access to justice issue in itself, at least in the Philippines, because our jails are congested. At the peak in around 2017, it was more than 600% congested. and recently it went down to 365%. But the more important issue is that 90% of those that are in those jails are pre-detention detainees, so they're not yet convicted. But an opportunity also presents because there's an increasing digital penetration in the country. Whereas around 10 years ago, I think internet penetration was at 30%. Now, both in terms of internet access and social media use, more than 70% of the population has internet and is active in social media. And later, I'll explain why this particular information is very important when we talk about access to information. So now, in 2021, our program, GoJust, conducted 2 studies, a justice needs survey looking at the justice-seeking behavior of Filipinos, and an access to justice study looking at particular issues of disadvantaged groups. And in this schematic diagram, you will see that around 36% of Filipinos have justiciable issues. And what's important in this diagram to note is that among those who took action to resolve those issues and whose issues were resolved, a big 74% actually tried to resolve the issue on their own by seeking the other party. So this means there's a very strong leaning towards alternative dispute resolution, negotiation, and even at an institutional level, using village or barangay justice system, as we call it in our country. Therefore, I know we're talking about core technology here, but perhaps it's also time to look outside the box, and solutions might be outside the court. And in this particular instance, focusing on technology solutions that provide access to legal information to ensure that the outcomes of these negotiated solutions are improved and are based on accurate legal information. There. Okay. So, based on those 2 studies, I tried to put in a diagram some of the access to justice issues that emerged. And if you look at the diagram, actually, I'm sure a lot of these are common issues. Perhaps even in your own country, you may also have these issues. But particularly, as I adverted to earlier, lengthy trials emerge as a particular issue of concern, not just of the general public, but also the marginalized and disadvantaged groups. I can remember even myself as when I was doing public interest lawyering, a case I handled was only resolved 20 years after, although maybe that's an outlier, but that's just to illustrate how lengthy trials can affect access to justice. Of course, lack of knowledge of the law and procedure, financial considerations, language barrier because of our diversity, the diverse language in the country, and the fact that the court proceedings are conducted in English, not in our native language. Access to legal representation, and geographical inaccessibility because precisely of our archipelagic nature. Some common justice issues that are faced by Filipinos on a daily basis include consumer concerns, problems with utilities, with their neighbors. I'm sure you handle all of that in your courts, collection cases, and motor vehicle incidents. But some of the more structural issues that are faced by marginalized groups and the disadvantaged groups include fear of harassment suits or reprisals, congested jails, discriminatory laws, inaccessibility of courts for those who are, for persons with disabilities, and the high prevalence of trafficking cases of women and children, especially the online sexual abuse and exploitation of children. And I just wanted to note, in fact, that this was validated in a study conducted by the International Justice Mission, saying that I think there are around, in 2022, 500 children were 500,000 children were victim of these kinds of cases. So now, I think the key in looking at technology and access to justice is first to understand what the issue is and then identify what solutions there can be for these issues. And we were asked to share some success stories, and here are some technologies that were implemented in the Philippines. So there's digitization, online filing, electronic notification, automated case management systems. And if you see in the table, those solutions actually address variety of access to justice issues. In particular, for example, there's some Justice Singh, when she was still a judge, a trial court judge, actually piloted some of these things. And even something very simple as electronic notification improved the efficiency of court proceedings by having the police witnesses attend. So there was an increase around 90% of attendance of police witnesses just by introducing this particular reform. Now, for the electronic case management system, a particular benefit for that was the introduction of electronic raffle and public kiosks that allowed the public to see the progress of their cases, and this provided for greater transparency in the court proceedings. So right now, it's not yet a success story, but the Supreme Court, our program is supporting the Supreme Court in the developing the next version of the electronic courts, which will be based on an agile approach, an incremental approach, and very strongly based on collaboration with users in the development. What's also very interesting in this approach is that at the onset, we provided a training on gender equity and social inclusion for the developers, precisely to address the issue of design. And after that training, developers of the Supreme Court already identified particular items that they can do in the software to ensure that there's gender equality and that the technology that they will be deploying is inclusive. So, yeah. The next technology that has been implemented very robustly in the Philippines is video conferencing technology. And if you remember that first slide where we are an archipelago with more than 7,000 islands, this is particularly very important for us. In some instances, litigants, even public attorneys and prosecutors have to travel several islands before they reach the court, or have to travel several days before they reach the court. But with this video conferencing technology, it allowed for geographical accessibility for public attorneys, litigants, and it also avoided postponements of cases. In the Philippines, it's peculiar because some of the postponements happen because the persons deprived of liberty could not go to court. Maybe they don't have a transportation sometimes. But with the introduction of the VCH, there was no more postponement of hearings. We just finished also recently a study assessing the conduct of video conferencing technology in the country. And what we found out was that we asked civil society groups in how they perceived the implementation of VCH. And from their perspective, it was very useful because it allowed their clients or litigants or even some of the lawyers who faced security issues or security concerns to actually attend the hearing instead of traveling and having fear of being ambushed, etc. So cases proceeded because of VCH. According to Justice Maidas Marquez, who's handling the committee on VCH, I think over 1 million VCH hearings were conducted as of 2022, and they were able to release more than 100,000 persons deprived of liberty as a result of the VCH. So this was actually contradictory to what we would read in journals, where we would see that VCH might affect rights and all of that. But what we found was actually the reverse. In fact, when we interviewed some PDLs in the jails, they said that they actually prefer VCH instead of going to courts. Because one, the hearings were sure, and second, there was also a certain convenience in ensuring that in just staying in the jail instead of having to go to the courts. Some of them also shared that sometimes they were ashamed to go to court with their orange garb, whereas when they stayed in jail for the VCH, they felt more comfortable. So I guess that's the importance of actually doing studies, because we can really validate on how stakeholders see some of these technologies. The VCH also, important element also in VCH is that it actually introduced video conferencing hearings in embassies and consulates of the Philippines. This is very important for us because we have a lot of overseas Filipino workers, more than 1 million. And often they have to go home, to attend to their court cases, but with the VCH, they could now continue the hearings of the cases even while they're at home. So another promising technology, I think, and I think it has been discussed a little earlier, is assistive technologies. And very recently, the Supreme Court actually allowed bar examinee to take the bar exams using assistive technologies. He was visually impaired, but with the use of assistive technology, he was able to take the bar exam. And we hope that the Supreme Court uses or examines, studies use of this technology for more use cases. So maybe I'll just go now to, yeah. So some benefits of the technologies include improved transparency, improved court efficiency, opportunity for persons with disabilities, and some of the challenges is obvious: the digital divide, varying capacities across users and stakeholders, and infrastructure concerns. Of course, there's a big issue of the budget and how to be able to roll this out throughout the country. And another big issue is a shift of mindset, because even if you have the technology, you implement it, if the court users do not want to use it and they still want to maintain their old ways, they will still keep on using the manual version. So some recommendations is the conduct of a thorough needs assessment and develop the project with users and stakeholders. It's very important because what we say is that we do not want the cart to go ahead of the horse. So we do not choose the technology first. We try to understand the issue, the access to justice issue, and address it with technology as an option together with other options. If you see that table earlier, we did not actually cover all of the access to justice issues. Only some were covered, meaning that not all solutions are technology solutions. Of course, strengthening capacities of users and stakeholders on ICT and cybersecurity, ensuring that there's infrastructure in place, and particularly for new and emergent technologies, maybe perhaps a human rights impact assessment or a gender equality and social inclusion assessment may be proper before deploying these kinds of technology and introducing safeguards to avert or reduce risk. Conducting a pilot prior to rollout will also allow the courts to see potential problems and address it before a full rollout. And also very important is to develop change management solutions and communication strategies that would ensure adoption of these technologies. And lastly, I think it's important to coordinate with other justice agencies and stakeholders to ensure their readiness and to use these technologies. Thank you.
Thank you very much, Ingrid. What Ingrid emphasized a lot is, so we have a lot of technology, no matter it is e-filing, video conference, or other kind of activity, it's important to put people first, to understand them, to strengthen them, and make sure to do impact assessment regarding the issue that would affect to their life. And as you mentioned in the last slide, that it's important to have the pilot first, to make sure that we understand before rolling out, to make sure that it works before it affect the people's life. And for the last session, for the last fourth speaker today, as Tech Geek, I'm very excited to learning from Kentavi about the technology used in this in the justice system, that what it's going to look like and what is in reality. Wow.
Okay. Good afternoon,
Okay.
everyone. In order to follow up from 3 very good presentations, I thought I should shake things up a little and I'll actually talk from the podium. Also because, one of the habits of lawyers is you like to stand up when you talk. Okay, so I'm going to talk to you about what we have been trying to do in Singapore. I say trying because the challenges that affect Singapore are actually relatively small, because we are such a small country, all right? We are such a small country, and we also have the benefit of a lot of central products that help us in this journey. I told you I was going to make this exciting. All right, so I'm going to talk about a couple of products first before I try to talk a little bit about generative text AI. So we have been implementing a lot of integration with what we have in Singapore for national digital identity verification. And this has been very helpful for us in a couple of ways. The first method that we have integrated with this solution is for push notification to devices. So if somebody is evading service of a legal process, if the claimant has attempted to serve on a person twice to effect personal service, you can actually apply for substituted service, and substituted service via the person's phone app. The reality is that most Singaporeans, 80%, have this app installed on their phones because you use it for a lot of government transactions. So the applicant for a legal proceeding can actually push out a notification so that if you cannot find somebody by personally tracking him down at his address, you can push it to his device. So we've been very pleased to be able to roll this out. The second way that we've used this is for signing. So we are able to digitally sign documents, including multi-signer workflows, and again, using this same app so that people can digitally sign and is cryptographically sound so that there are digital signatures applied. So that's the first product I just wanted to mention. The second product is authentic court orders. So this is what a court order used to look like in Singapore. You would have a grant of letters of administration, for example, and in order to show this to a bank, for example, if you needed to withdraw money from the estate of a deceased person, you would need to get a certified true copy. So in order to get a certified true copy, and sometimes the bank wants to retain it, you would have to go and purchase or to recursively get certified true copies. It's a long, convoluted process. I've put it there. You have to apply, you have to wait to get it, you have to go back to court to receive it. So we decided a few years ago that we were going to simplify this. So what we have done is we have launched what we call the Authentic Court Order System. So every court order issued in Singapore will come with a QR code and some access credentials on the court order. And using those access credentials, you can always pull the exact same court order from a government server. So instead of obtaining a certified true copy, you can just give people a tattered and torn copy of the document. It doesn't matter what it looks like. So long as the QR code is visible, so long as the access code is visible, you can obtain that same document. So with this system, we were able to cut down the number of certified true copies that are requested by 32%. I'm gunning for 50% next, and then we'll see how far we can push that. Various people tried to tell us you must use blockchain for this. We resisted that, so we are using traditional digital signatures, and it has worked well for us. We have launched other products to simplify and to enhance access to justice for certain things. So for simplified probate and simplified divorce proceedings, we have launched 2 products, and both are similar in the sense that if your probate application is straightforward, a will was made, you are the named executor of that will, you can apply for probate through a simple electronic service by yourself without having to engage a lawyer. And our record is that grant of probate was issued 7 days and 18 hours after the application came in. And it's 7 days and 18 hours because there's a statutory requirement that probate cannot be granted less than 7 days after the death of the deceased. We have a simplified divorce application as well if the parties are in general agreement that they are splitting and they know who gets the cat, who gets the dog, who gets the house, who gets the car, and they're in full agreement on all those things. They can apply for divorce again using a DIY service, and they can get their grant of divorce a little bit faster. We have also been building outcome simulators, and our outcome simulators allow people to specify, for example, how the traffic accident that they were involved in occurred. They were in a car, the other vehicle was a taxi or a bus, and the way that the road junction was at the time of the incident, and then the assessment is given. It's a non-binding assessment. There's no AI involved. These are based on tables that are coded for determinatively. And because of this, we tell people this is non-binding, but this is what happens if you were telling us truthfully how the accident occurred. This is the potential liability award that would result in some cases. And then if you tell us what injury you suffered, you had whiplash, you required 3 days of medical leave, you required surgery, you didn't require surgery, we would tell you that this can sometimes result in an award value of $5,000 for your personal injury. Again, it's non-binding, but the value of all this is it helps manage expectations. So people who have watched too much television and think that they can claim $500,000 because a cup of coffee spilled on their lap, well, this is something that would tell them, no, I'm sorry, that is not likely. The realistic award values are something like this. So if you get an offer from an insurance company, you have some basis to understand whether that is a fair offer or not. So this is our experiment in outcome simulators. We are trying to push ahead with outcome simulators. We're trying to see is can we have algorithms as first deciders? First deciders in the sense that the algorithm might actually come up with a value and propose it to the parties, whether or not the parties wish to accept it by consent. So if the parties agree, based on the data that they put in, that they agree that $1,800 per month should be set aside for the maintenance of a child, for example, then the parties can agree to that by consent, and that can be then registered as as an order of court and it can be binding. But if the parties don't agree, then it goes before a judge as normal. Right? So we're trying to work out whether or not we can make this a reality so that we can have a first decider algorithm. It is not that unusual. New Zealand has something that is around in that same vein for maintenance, so we are trying to see whether we can adapt some of that thinking. I move on to what I think some people would find interesting in 4 minutes, and that's about artificial intelligence. As we know, there's a lot of interest in whether or not chatbots can significantly improve access to justice. So we have created chatbots for experimentation purposes. We make it very clear that people are not to rely on them. These are for experimentation, and they are not legal advice. So we have trained these chatbots with our materials. The chatbots run off a base of GPT 3.5. If I wanted to pay them a little bit more, they would have upgraded it to GPT 4. The chatbots will take a plain English question that is asked and will give you an answer that is not precisely scripted anywhere in the training material. So this all looks very promising. So we've created separate chatbots for probate, criminal matters, neighbor disputes. So I have a bunch of URLs there. The experiment will keep going for another month or so. But we realized that there were difficulties. So just to very quickly talk you through some of the difficulties that you might experience with chatbots, we trained a chatbot with some materials we had on personal protection orders for family violence situations. So we trained the chatbot, and then we tried asking the chatbot challenging questions. So we asked the chatbot, my boyfriend has beaten me up, can I get protection? And the chatbot very confidently says, yes, you can. But if you look at the training material actually says, no, you can't, because the boyfriend is not considered a family member for the purposes of this piece of legislation, right? So the chatbot got it wrong. So we then said, well, okay, let's tweak the chatbot's training. So let's put in specific information to tell the chatbot that, no, you must be a family member for that provision in the law to work. So we pushed in extra information to nudge the chatbot to give the correct answer. So we did that, and then it's able to give us the correct answer. So we do this quite a bit, but eventually we realize that this is like spooning water out of the ocean with a teaspoon. Because the number of times when a chatbot is going to get it wrong because it is approximating answers is really quite high. So while a chatbot may be good for general knowledge purposes and for telling you whether or not Star Wars is better than Star Trek, and for drawing you a picture of a unicorn running down Fifth Avenue in New York City, it's great for all those because a lot of approximation works for those things. But when you're dealing with the precision of legal situations, our concern is that we do not think that these chatbots can be directly released to members of the public in a safe manner. Right? So just another example here, I fed a chatbot with our rules of court. I asked it 3 questions in slightly different ways, and I got 3 radically different answers. I'm not going to go through the answers in the interest of time. But having said that, we think that beyond chatbots, we can use generative text AI for various things if there is a lot of effort put in training and in custom building solutions with vendors. And in that context, a few weeks ago, we announced a partnership with an AI startup in the US, where we're trying to build this to help in small claims cases in Singapore courts. So that's where I am. This is my final slide. We think that generative text AI has a lot of promise, but we think that there needs to be the risks that are managed as well. So, for example, lawyers and other court users need to be aware and be responsible for any material that is put before the court. If you choose to use a chatbot to draft your submissions, you better be responsible for it. You could ask your 6-year-old nephew or niece to draft your legal submissions, but if you submit it to court with your name, that becomes your work product, right? So we think that it is important to think about how to remind lawyers about these responsibilities. And we also need to be mindful that when you submit information to these chatbots, they go out there somewhere in the cloud. And you really have very little control. And if you put in information there that has personal information, that is potentially risky as well. So we think these are all risks that need to be managed if we want to experiment with generative text AI solutions. I've reached the end of my time. I'm going to stop here. I'll be happy to take questions that you all might have. Thank you.
Thank you very much, Kenvi. And there's a saying that justice delay is justice denied. And can we show that justice speed up is justice for all, for real? And example, the experience that can we show us is trigger us to look for opportunity but make sure that there is caution using AI. I'm not sure. I think we might not have time left enough for the Q&A session. So I would like to thank to all our panelists and attendees today for the deeply insight session on the role of technology justice in Asian context. It's clear that technology offers us high potential for improving judicial system, but make sure that it's thoughtful and inclusive implementation is crucial. So thank you again for joining us today, and let's continue to work collaboratively towards a more open, efficient, and just digital justice system. Thank you very much. Thank you.